on to the breaking news on your screen. As we indicated, Mallya has filed an affidavit in the Supreme Court in loan default case. Ashmit has details on what that affidavit contains. The affidavit has said Vijay Mallya has told Supreme Court in that affidavit that banks have no rights to know information about Mallya's overseas assets. In fact, they've said that banks cannot get details as banks were not involved when it came to restructuring Mallya's overseas assets. In fact, the affidavit also goes on to point out that NRIs are not obligated to disclose their overseas assets and that the affidavit is seeking permission to file details of assets in a sealed cover. So essentially what Mallya is saying is that banks do not have a right to knowing his overseas assets. They were not involved when he was restructuring their overseas assets, and as a result of that, they are not obliged to getting details, and they are asking the Supreme Court for permission to file the details of assets in a sealed cover. We'll get your reactions from lawyers to understand what this means and if at all this can have any meat as far as the case is concerned. Over and above that, all right, we have Ashmit with us. Ashmit, we are getting details trickling in. Take us through the details of the affidavit. Exactly what is his argument for not disclosing the assets? And is there any timeline that he's provided as to when he will be able to come back over here?
Well, we're just going through the affidavit as we speak, but what we have been able to gather so far is that what Mallya is arguing by way of this affidavit is that the banks have, at this point, do not enjoy any right to secure information about Mallya's overseas assets. So that's directly in contradiction to what we have been hearing from the bankers. So this is a case of Mallya refusing to disclose on that front. He also further goes on to say that banks cannot get details because the banks, as per se, was not involved in the restructuring of his overseas assets. But this one, pertaining to his overseas assets, Mallya clarifying that banks cannot intervene, cannot get details. They were not involved in the process in the first place. Finally, he also goes on to argue that NRIs, as an NRI, he's not obliged to disclose assets that are lying overseas beyond the jurisdiction of Indian courts. And he also goes on to add that he will in fact seek permission to disclose whatever assets in the limited capacity of a sealed envelope before the apex court. So that's one exception that he's prepared to make. But that's, of course, details not being disclosed to the banks per se. That will be then left to the discretion of the apex court. What he also, in fact, goes on to say, and this one, pertaining to his immediate family, here Mallya clarifies that his immediate family is under no legal obligation whatsoever to disclose these assets, and that KFA was strictly speaking a business venture, and that there is no reason to look beyond that. So these are the details, and as we speak, we're getting more details with the affidavit. But clearly, at this point, what does appear to be the position that Mallya is taking is that as far as the critical question of disclosure is concerned, Mallya has taken an adversarial view. Mallya clarifying that at no point does he feel that he's bound by any legal obligation to disclose his assets lying in India, overseas, or assets of his immediate family lying overseas. So clearly, that's the tone and the tenor gauging from the affidavit that Vijay Mallya has filed.
Ashmit, there's another important point that has been mentioned over here in the lines that you have said with respect to the affidavit, that Mallya's affidavit seeks permission to file details of assets in a sealed cover. Essentially, they do not want to disclose it to the banks, but they will disclose their assets or the details of the overseas assets to the Supreme Court directly and not the investigative agencies, if I'm correct. Ashmit, if you can hear me, I'm trying to understand exactly what he means when you say if he's seeking the details or seeking permission to deliver the details and disclosures of their overseas assets in a sealed cover. Is this directly to the Supreme Court, or are they asking for protection of those details not going to the banks and the investigative agencies?
Well, of course, one has to keep in mind that the Supreme Court had clarified to Vijay Mallya that to avoid any adverse action from the apex court, it was incumbent on Vijay Mallya to act in a responsible manner to showcase his bona fides, and that's essentially what he's doing here. The details were sought. He's not disclosing the details to the bank. He's making that distinction, but he is, as per the affidavit, likely to submit those documents about the details of the assets to the apex court in a sealed envelope. And then we understand that his counsel will be arguing about non-disclosure to the bank. So at least on the question of establishing bona fides before the apex court, he's willing to go the whole 9 yards. He's coming forth and displaying that before the apex court. The question mark, of course, here is that it's being done in a sealed envelope. And again, as we speak, going through the affidavit, what we also are picking up is that on the question of establishing his bona fides itself, on that same question, Vijay Mallya has also come forth and said that he will be depositing a token amount of 1,590 crores before the apex court, and this will be done by this will be deposited to the Supreme Court registry as a show of good faith that Vijay Mallya is in fact well aware and cognizant of his responsibilities towards the creditors, and that he will be meeting those obligations. So as a token gesture, Vijay Mallya will be coming forth to deposit that token amount of nearly 1,600 crores.
So if I could take me through the exact details of the token amount. Has he given any timeline as to when that amount will be submitted? It's 1,590 crore rupees, correct?
We understand exactly. That's the amount that we are speaking of, 1,590 crores. The timeline so far is not clear, but one would imagine that it would be near the next date of hearing, which is April 26th, which just gives us a few days away. Which gives Vijay Mallya a few days. But of course, the key aspect here is that Vijay Mallya is trying hard to establish his bona fides before the apex court. That's the key message that's coming across. One, seeking to disclose the assets not before the banks but in a sealed envelope to the apex court, and also in fact coming through on the direction that had been given by the apex court on the need for depositing a token amount, coming forth on that and clarifying that a sum of 1,591 crores will be deposited in line with the earlier Supreme Court order seeking Vijay Mallya to establish his bona fides.
Ashmit, I know you're going through the affidavit as we speak. Any clarity with respect to when he is expected to come down to India? Because lawyers have, of course, been asking for time. MEA has given him time of about a week to reply. The deadline expires tomorrow. Any clarity as to when they will respond to MEA, or when he will give some kind of timeline as to when he will be coming down to India physically?
Well, sifting through the pages of the affidavit, one must confess that the question mark still lingers, the question mark still looms. There's not sufficient clarity on that. The big question that the apex court had asked at the last hearing, when is Vijay Mallya expected to return? When can he appear before the apex court? These two questions, sifting through the pages, one gets a sense there is no clarity on that. So that is something that that question mark still remains. So that is one aspect that his counsels, I believe, will need to answer, along with, of course, on the questions of the token amount, on the question of disclosures.
Okay.
That will be the key question that I guess the counsels will have to address. But for now, sifting through the affidavit, there does appear to be the conspicuous absence as far as his date of return is concerned.
Okay, Ashmit is going through the affidavit as we speak. So, Ashmit, hang in there and go through all the other details of the affidavit. But let's bring in an expert as well. Hitesh Jain is joining in to help us understand this. Hitesh, a token amount has been offered of 1,591 crore rupees as a gesture to be deposited to the Supreme Court. But it's still very conspicuous as to how this will work and when he will come in. And do you think that his argument that banks do not have any right over his overseas assets holds any meat whatsoever?
I think that's a very frivolous technical plea on which he's relying. See, under the Income Tax Act, for the taxation purpose, an NRI, one can understand that the NRI did not disclose his foreign assets and bank account, but that is for the purposes of provision under the Income Tax Act. Now, here, when the banks have filed the proceedings, these are the proceedings for recovery of money. And when there is a charge of fraud and siphoning of assets, then perhaps he will not be able to get the benefit of the plea under the Income Tax Act, which is available to the non-resident Indian, and that is purely restricted only for the purpose of whether your income is taxable, and from that perspective, whether the foreign assets should be disclosed or not. That is one. Second, I have always maintained that, this whole tactics of offering 4,000 crore, now offering 1,591 crore, I do not have the benefit of reading the affidavit. But if he has offered this money without any conditions attached, and unconditionally if he is offering this money and then he wants to cooperate in the investigation, that is altogether a separate question. But if you just simply say that for the sake of placing on record, you just maintain that, okay, I'm ready to deposit, but without giving details as to when the money is going to come in, whether it is subject to certain conditions and all, that means he's trying to again try to take the advantages. This is just he's trying to take. He's just creating some excuse, one excuse or another, to avoid joining the probe and to avoid the cooperation of investigation, and then play a card of victim that I was ready to pay and the government is still, all the authorities and banks, they are taking a high-handed action against him.
Okay.
So overall, if you will see the approach in the affidavit, there is no cooperation forthcoming, and one will have to look at the affidavit, this plea which has been taken about the NRI and not the disclosure not required. I don't think that is going to fly with the court.
Okay, let's bring in Gopal Jain as well before we quickly wrap this discussion up. Gopal, does his argument with respect to not having any obligation to disclose his overseas assets have any meat in it? And more importantly, would this in any way impact ED's case of the non-bailable warrant and trying to deport him back to India?
Look, I think the most important thing is you have to do a reality check and your response has to measure up to the situation. Now, there are several court proceedings pending, including in the Supreme Court. There are a significant amount of money which you owe to banks and institutions in India. Many of them have been earned out of businesses in India. You've taken the loans in India. So you do have a legal responsibility to discharge them, or in any instance to come up with a proper mechanism towards settlement. So this approach looks more evasive, as if to say that, look, I may be a defaulter, I may have taken loans, but I'm making sure that the assets which I have abroad, I'm going to insulate it from these proceedings. I don't think it's a step in the right direction, given the overall context, the fact that ED is issued and courts have issued summons. So I think cooperation and intent is most important at the moment.
All right, Hitesh Jain and Gopal Jain, thanks for joining in on this show.